The series deals with things that we would find that clients give us a call about and say, we're having such and such problem. So we came up with the name for the series because we find that clients, usually practice administrators or CEOs, would call and say, usually followed by a loud, audible sigh. We're having a problem with this, Ann. Can you help us out? Do you have a few minutes to discuss it? And so as we see trends, we develop our series webinars around these activities. So just a few housekeeping things here. We're going to talk for probably about 45 minutes. You have your lines currently all muted. I'm going to try and unmute those at the end of the call and allow some time for some questions. But if you could just hold your questions till the end, that would be great. And I'll go ahead and mute the lines here, just in case you need to have a discussion with somebody else while I'm talking. And we'll go from there. Does that sound good? All right, so let's go ahead and get started. I've been working on physician employment agreements now for about 17 years. And I've done everything from represent the individual physician who's straight out of residency or fellowship, all the way through to developing template agreements for large groups, for hundreds of physicians at a time, trying to create some sort of template that can be used as a basis for all the physicians in the group, including when there already were existing employment agreements. But for the most part, most of the work that we do on physician employment agreements is usually a physician who's perhaps mid-career, who's switching companies, switching employers, and wants to make sure that his or her business skills and time are protected, and so they come to us with a contract. I'm going to focus my talk today on these 7 issues for the most part. And rather than talk about which side you're on or talk about different strategies, I'm going to talk about these 7 issues and talk about the strategies and the different sides within these 7 key points. And then at the end, I'm going to talk a little bit about how you can make the most of your legal dollars when using a healthcare attorney to negotiate your agreement or to evaluate it for you. And then just some kind of basics and some strategies that we use here about how we kind of proceed with employment agreement review. All right, so with that, let's just dive right in here. 7 key points to look for in employment agreements. Let's give just a brief overview first. One main subject is term and termination. I was just with a client for a 10 o'clock appointment this morning, and one issue was, is his agreement for the term of a year, or is it an at-will, or gosh, it doesn't really say the term. What is the term? So it might not seem all that important. It's one of those issues that your eyes might glaze over if you're not aware of some of the big issues that can come with that. We also take a strong look at termination. What are the rights to terminate the physician, or what rights would the group have to terminate the physician? And likewise, what ability does the physician have to leave, considering it can take a long time to get credentialed to other places? The second issue that we talk about is the one that our clients typically care about the most, and that is the issue of compensation. The compensation terms have become highly complex. Here on my desk is what I refer to as my Bible. It's a lovely green book that's the MGMA Physician Salary, Physician Compensation and Production Report, which tells the ranges from the MGMA survey. So compensation is a big issue, and we refer to that book frequently. The third main issue is that of bonus and benefits, kind of tie into the compensation structure in general. We also spend a lot of time on our 4th issue, malpractice insurance, and we're able to kind of figure out what the coverage is, what it should be, and what to do if you're not getting what you want. Duties and responsibilities isn't that big of an issue. It doesn't take up that much space within the contract, but there are some key issues that we look for to sort of protect physicians' lifestyles, or reciprocally to protect the group's investment in the physician. Non-competes are right up there with the insurance issue of tail coverage as probably the main issue that I deal with. Certainly the issue that I deal with when physicians want to leave a group is the non-compete. Before they give their notice, they often come to me and show me their non-compete clause and ask what they can do. So we'll get into non-competes, which is very state law oriented. And then finally, we'll talk about future opportunities, profit sharing, and being on the partnership track. So let's go ahead and just look first at term. You know, in Florida, as in many states, and if you're kind of thought of to be as an at-will employee, meaning they can fire you at any time and you can quit at any time without cause, unless you have something in writing that states otherwise. So what usually takes physician employment agreements outside of the at-will status is the fact that there's a contract that states the term and the termination. What we typically see is some sort of a fixed term coupled with an automatic renewal clause or an evergreen provision, sometimes referred to. So we'll perhaps see language that reads something like this. The term of this agreement is for 1 year, provided, however, that this agreement will automatically renew for subsequent 1-year terms on the anniversary date of the term. Something like that. So it just kind of goes on forever, which is perfectly normal. Some people say it seems like indentured servitude. However, it is legal and normal in a contract to have something like that. However, it really should be coupled with some sort of way to end it, termination with cause and without cause. One thing, I had a physician come to me once and say, hey, look at this contract. This is like an NBA, National Basketball Association style contract. It's for 5 years, and it says they have to pay me throughout the 5 years. And then I scrolled down, and I pointed out to him the without cause termination section, which said that this agreement can be terminated without cause upon 90 days notice by either party. So I pointed out to him that his NBA contract was really nothing more than a 3-year contract. And that's something to keep notice of. Whatever the length of the without cause notice period is really how long the contract really is. And let me delve into that just a little bit deeper. Without cause notice. That provision usually says something like, either party can terminate this agreement without cause by providing written notice no less than 90 days in advance of the termination date to the other party. So it's really a notice period that we're talking about. And I often get asked, well, do we want to have a strong without cause termination provision, or do we terminate for cause? Some clients like to list like 25 reasons for cause. And the fact of the matter is, in my experience representing groups who perhaps might want to let a physician go, is oftentimes it's better not to say the reason because then you could be sued for that not really being a legitimate reason if it turns out to be not a factually sufficient basis for terminating. So, in the real world, when a group wants to let a physician go, they often let the physician go without cause according to that 90-day notice period. Another question that I get is, am I going to be paid throughout that notice period? So if a physician came to me today and said, I want to give my 90 days notice, do they have to pay me through that 90-day period? And there are lots of nuances in contracts that might give rise to a different interpretation. But generally speaking, if they have the right to terminate you for cause, and those exist, and they can fire you for a reason, you're not guaranteed to work there and just go home and lay on your couch for the notice of termination. You have to still do your job, and so they still have the right to fire you if you don't do your job, even though you're within that notice period. However, they would need cause to let you go during that period. Another twist on that is if I'm representing the group and the group asks me, okay, he gave us 90 days notice, but we don't really want the guy around. Can we just tell him to stay home and we'll pay him through the period? Absolutely. The only time that can get a little dicey is if the compensation is based on productivity. And so if he's not going to be productive, obviously, because he's not working, so how do you pay him, or what do you pay him? So sometimes we'll address those proactively in the agreement, or sometimes we'll do a little amendment at the time or come up with some sort of settlement agreement. But as you can see by my last 5 minutes of discussion, subjects that seem as simple as term or termination can really be quite complex when applied to the real world. Another word to the wise about without cause notice periods. Usually they're reciprocal. So it's usually either party can terminate the other without with X number of days notice. We usually see somewhere around 30 to 90 days. So it might say 30 days, it might say 60 days, it might say 90 days. Know that if you're a physician who's negotiating their own employment agreement and you want to leave and go somewhere else, there is no way that you're going to get credentialed through Medicare, through the payer plans in less than 60 days. So if your employer can let you go with 60 days notice, sure, you might be able to get an offer somewhere else, but are you going to be credentialed and be able to make some money and have some cash flow for that employer? So that's a big issue when we're setting whether it should be 30, 60, 90. I saw one that was 4 months earlier today. Others can be as long as 6 months, but usually they're at least a month in this sort of a profession. Let me touch briefly on the for-cause provisions. I almost always see something that's very definitive or distinctive, like you lose your license. That's grounds for termination. You lose your DEA registration, things that can be factually verified. Where it gets a little dicey is things that are subjective. For example, there was one that I saw not too long ago that said the group could fire the physician if the group felt that he was not contributing to a positive work environment or something like that. It didn't even go so far as to say, was creating a hostile work environment, but it was something that was kind of like, if we just don't like you, we can terminate you. And the thing with for-cause termination is it's usually immediate. So if the penalty is that drastic, as attorneys, we really want the agreement to be as definitive and clear as possible. Sometimes if I see one that's kind of subjective, or if it's something like failure to abide by policy, I'll then counter back if I'm representing the physician and say, okay, well, it would only be reasonable for my client to have an opportunity to know what the policy was that he violated and to have a cure period. So what we might do in that situation is amend the language to say, provided, however, that physician has a right to notice of what the policy violation was and the opportunity to cure the breach over a 30-day period. Something like that to make it a little bit more fair when we see those things that are subjective or perhaps seem kind of unfair. So even though you see this really long list of all these things that they can fire you for, that you can fire for, from the physician side, you want it to be as distinct as possible. From the group or employer side, you typically want those to perhaps have some wiggle room there. Does that make sense? All right. So let's move on to my second subject area, and that is compensation. So like I said, this is the one that the physician's eyes usually go to first. And this has certainly evolved in the 17 years that I've been working on these. We used to see almost always some sort of flat salary, especially back in the early 90s when there was the last round of influx of physicians being employed by hospitals. And the hospitals seemed to lose a lot of money off their employed physicians. So this time around, they're including productivity in a base salary component. So we're seeing now a lot of contracts that are based on wRVUs. And I'm going to talk about wRVUs a little bit more in the bonus section because they're often more thought of as a bonus. But we usually see some sort of base salary, $100,000, $200,000, $400,000 a year, with some sort of productivity. If a physician is going to a new location, we might see some sort of overhead considering there are startup costs, kind of to get the new location going, that it'll take some time to build clientele there, so on and so forth. loan forgiveness can be a subject of this talk in and of itself for another hour, but let me say this. There are federal loan forgiveness programs. So if someone comes to you who's a resident and says, yeah, I'd like to go work here, but can you take care of my student loans for me? Unless you're in a healthcare professional shortage area, those programs don't really apply. So the first thing you want to do is see what kind of program might be involved. Does your group fit within that? And vice versa. You know, the physician would want to make sure that everything's legit there and have it go through the federal program if it can. If it can't, I think that groups need to be mindful that if they pay student loans on behalf of their employee, that's considered taxable income to the employee. So you got to report it, and the employee has to pay taxes on it. So be very careful about how these are structured. If you help them, you loan them money too, while we're on the subject of loans, not just student loans, but if you loan them money for startup costs, and then you would forgive it, remember that forgiveness is also taxable income to the employee. So that can get a little dicey and result in some very uncomfortable situations on April 15th if you're not careful. Reimbursed expenses. Most employers agree to reimburse physicians for their state license fees, their DEA, for professional societies, and usually we'll list what professional societies that might be, or maybe list a number, those kind of expenses. Most employers pay a stipend for continuing medical education. I usually like to make clear that handles not just the tuition to participate in the program, but it also would include travel, hotel, that sort of thing, especially if the physician is in a specialty that requires him or her to travel to get good CME. And of course, the license fees, usually a cell phone, usually gas, that sort of a thing. But it's important to address those up front just so they can be clear. You would be surprised, or perhaps not, how little issues like reimbursed cell phone expenses can create some problems in employment agreements. So that's compensation. Let me just move on to the bonus aspect of compensation. Sign-on bonuses seem to be quite predominant now, anywhere from 5 to 20. I even saw one that was $50,000 not too long ago. We typically see those as you get half of it when you sign and then half of it when you get your first paycheck. And those are usually legitimate. You want to make sure for fraud and abuse purposes that they're not too high. But for the most part, a sign-on bonus that's reasonable in amount and added to the total compensation when looking at reasonableness is very normal. Now let's talk about annual bonuses. I once had a question from a group. Do you think that we should incentivize our physicians? And I do this a lot, like help physician groups that have been paying their physicians on flat salaries historically try to transition into a incentive compensation model, and how should we structure it? So they'll say, well, do we want to do our incentive or our annual bonus based on RVUs or based on collections minus expenses, so on a more of a profit scale? And my answer is usually this. If you don't have the proper practice management tools to track RVUs in a good way, you don't have any business paying your employees based on RVUs. And so then the question is, well, I know it's a component in our practice management system. We've kind of played with it. Maybe we should go ahead and go the RVU way. And my suggestion is try it for a few months and see if they seem accurate. Make sure you're running the system right, running the numbers right, make sure things are being entered correctly and that sort of thing. And kind of do a trial run of tracking RVUs for a few months for each physician to see if it seems accurate before a physician group goes to an RVU model. I'm assuming everybody on the call knows what RVUs are, so we won't get into that too much. But we'll see a compensation structure that might be you get a base salary, and then once your RVUs for the year exceed a certain threshold amount, then you get a certain dollar amount per RVU. So what we do is we take our MGMA compensation and production report, and I provide some information to the practice to help them figure out, historically what would be a good threshold. If you haven't been tracking RVUs historically, you have no idea what to put that threshold at. So you have to be able to determine that threshold. You could sort of use the percentiles that are in the MGMA reports, but that's a little risky if you've never done it before. Oh, I think that we're probably at about 25th percentile, or let's go low this year. Let's go at maybe the 25th percentile and then kind of see how it goes. It's a little risky. So that's RVUs from the physician group standpoint. Almost all hospital system or health system, big mega employers, have an ability to track RVUs, and almost every employment agreement that I see that's with a system has an RVU structure as opposed to a collections minus expenses structure. So you can almost just count on it with them. If you are an employer and you are paying your physicians based on RVUs, I strongly encourage you from a long-term relationship and trust standpoint to make your RVU process very transparent. I think that every physician should get a monthly report that states what their RVUs were. If they have questions, someone should be able to answer them. Trending over the year would be wonderful. Not only does it help with physician buy-in into this compensation structure, it also helps them see, oh gosh, yeah, I really did slow down a little bit in September. Look at that. I need to pick it up. That sort of thing, which is the sole purpose of a productivity compensation structure, is to encourage the physicians to maintain or to improve their productivity. Let's talk a little bit about the collections minus expenses bonus or compensation model. Usually, again, I'll see some sort of flat salary, although in some physician-owned groups, they kind of take everything that they make if they're a shareholder based on collections minus expenses. But I'd like to say, I see I have a capital C on collections here. I don't have a capital C on expenses. I probably should, because I always like to point out that what collections means is a lot of things, and expenses can include a heck of a lot of things. So we usually define those. We say collections are everything that the physician personally performs. Depending on the employer, it is legal to include incident to billing from physician assistants or PAs in that compensation or collections. No, let me just take a step back here and say that how you pay your physicians comes under the Stark Law if you're physician-owned, and the anti-kickback statute or Stark Law if you're system or company-owned. So you might not think of it, you think of fraud and abuse with outside parties, but the biggest trend in U.S. attorney cases against health systems and physician groups is that they're paying their physicians internally, their employed physicians, in a way that violates federal law. So we need to be very, very careful about how this works. Collections cannot, in most settings, include designated health services. Designated health services are those services under the Stark Law that the government has said physicians can't be incentivized in their salaries based on how much of these designated health services that they do. Lab work is an example. Physical therapy is an example. Home health care, although usually applicable only in a big system, is another issue, is another designated health service. Prescription drugs are a designated health service. So you have to have this carve-out of what the physician's bonus cannot be paid to include. So we carve out designated health services from collections. One question that I've had a lot lately is, does the meaningful use incentive that my group got paid for our implementation of our EMR, does that go in my collections pot, and do I get a percentage of that? That's a tough one. It really depends on how the word collections is defined in the contract. Also, that we're seeing a big trend in payers incentivizing physicians and giving incentivized payments back for saving the payer's number. Some of you on the call might have received some checks from Florida Blue for the work that the physicians have done in quality or in metrics that they've imposed, that sort of thing. So not just reimbursement for services, for fee-for-service, but other reimbursements from the payers for their incentive and quality programs. Do those go into collections? Well, we've got to be careful in how we define that. So I talk to my group clients about these kind of things when we devise our contractual terms and our definition of collections. Of course, expenses is just as complicated. We often see some sort of group expenses. So rent at the 5 locations is split equally in terms of the overhead for the 20 doctors for purposes of the bonus. Rent, salaries, there's a lot of things that can be kind of split equally. And then often we'll see physician-specific expenses. So if there's one physician who always likes to go to Tahiti for his CMEs and his CME expenses are $10,000, that might be included in that section. So some of those kind of things that are more specific to individual physicians' needs go in there. But it definitely has to be listed, or you could include lots of things. And for the most part, it's not so much a matter of taking advantage of each other. It's a matter of these are where issues arise. I unfortunately do a lot of divorces in physician groups, and I can tell you that a lot of the divorces arise because people think that it's not fair the way the collections and expenses are being divvied up for purposes of the physician's bonus and salary. So it's really a good thing to spend some time and contemplate what is fair, and then to explain it to physicians who are not CPAs and who are not MBAs, why expenses are allocated as they are for purposes of their bonus. So let's move to benefits. We usually see everything categorized as paid time off, not so much sick leave. Sometimes CME, continuing medical education, is included in PTO. So, it's just nice to sort of flesh those out. Are they paid on national holidays if they have to work or if they're on call? Those sorts of things. Retirement insurance, how is disability defined? Those are all things that we go through for our groups and also work with our individual physician clients on. All right, moving to malpractice insurance. Malpractice insurance is almost always paid for by the employer. Independent contractors, locum tenens, they might pay for their own, but for the most part it makes sense for the group to not only pay for the insurance because they're your employees, but also you as the employer want to control the insurance company, which controls the defense if a claim is made. And we'll talk a little bit about that more with tail coverage. But the control is almost as important as the money that's spent. In Florida, there's lots of nuances, but for the most part, if you have hospital privileges, you have to have coverage that's $250, $750. So $250 per occurrence, $750 in the aggregate. There's a lot of different strategies, and that's the subject of a whole nother call about whether it's best to have $1 million, $3 million, or higher coverage, or whether that makes you just a greater target of for lawsuits. So, but no, for the most part, it's $250, $750. There are some tracks where you can be self-insured, where you can post bonds, that sort of thing. But malpractice issue absolutely has to be covered in the physician employment agreement. One of the main issues besides non-compete that physicians usually come to me with is that of tail coverage. And tail coverage arises only in the event that the employer had a policy that was made. So as we talk about tail coverage, our first question is, what kind of insurance was in place? Let me step back for a minute and tell you how this usually plays out. In a contract, there'll be a paragraph that says insurance, and it'll say the employer will provide insurance, professional liability insurance. It will be at limits that are $250, $750, so on and so forth, and it doesn't say anything about what type of insurance it is, and it doesn't say anything about tail coverage. So let's say I'm representing the physician in this situation. The first thing we need to do is find out what kind of coverage that 25750 is. Is it occurrence or is it claims made? A lot of groups buy claims made because it's cheaper. The costs for claims made policies are simply just cheaper than they are for occurrence. So for a claims made policy to cover a claim, the physician had to be working under that policy at that company when the coverage was in effect and when the claim was brought. So if you are a physician and you leave a practice, you retire, you go work somewhere else, and your prior employer had claims made policy, that coverage ended as of the day that you left that place. If, however, they had an occurrence policy, it covers it into the future forever. So you're good. You don't need tail coverage. But if you had claims made, it ended the day you left that place. So you need to have some coverage because your new employer, they're not going to cover you for what you did at the old place. They're only going to cover you for what you do under their employment. So, as you know, statute of limitations can be 2 or more years. So if a claim is made, on the midnight of the night before the end of the 2-year statute of limitations, what insurance do you have? If you had claims made at your old place and you didn't buy tail coverage, then your attorney's fees and any judgment are coming out of your pocket because you don't have any insurance to cover that. So the next step in the negotiation and analysis of this then is, well, who pays for tail insurance? If it's silent, then neither party is obligated to buy it. And most employers who are worried about finances, they buy claims made and they don't say anything about tail coverage. They might even say that the physician has to buy tail coverage. So then we counter back and say, well, employer, you should pay for the tail coverage. And that's when the negotiation can get a little bit fun. I often say if I represent the physician that if he's terminated before X number of years, then the employer should pay for the tail coverage. He's moving, he's committing here. If you fire him without cause, within the 2 years, he shouldn't have to pay that expense. I should add that tail coverage can be rather expensive, depending on the specialty and depending on how long the physician has been practicing, and especially on his malpractice history. If he's had any claims against him in the past, it can be quite pricey, anywhere from $10,000 to $100,000, depending on specialty and those other factors. So what that means then is tail coverage, in effect, becomes a roadblock to leaving a practice. So I often have physicians who come to me and say, hey, I'm thinking of leaving. What does my non-compete say? And I'll say, well, hey, let's talk about your tail coverage provision here, too. You're a cardiothoracic surgeon. It's going to cost you about $100,000 in tail insurance to leave this place. And that's when the jaw drops to the desk. So it gets pretty expensive. So a smart physician negotiates this ahead of time and tries to get the employer to pay. And if the employer won't pay the entire in every setting, maybe carve out some situations. Like if the physician leaves in a very short period, then perhaps he or she should pay for it, so on and so forth. So the reason for leaving, who triggers it, when it occurs, that sort of thing is important. I want to talk for a minute. I know this is kind of complicated, and I'm going to make it even a little bit more complicated here. But some carriers, some insurance carriers, will provide retroactive coverage if you stay with them, with that carrier when you go on to your new place. So if you were at practice A and they used ABC carrier, and you go to practice B and they also use ABC carrier, they might be able to just write your start date retroactively and then continue the policy on. That's a great solution. So that's sometimes hard to find out. Like sometimes, you might not have the ability to say, so who do you have your insurance through? Because it'll tip off that, you're going to leave. But that's also another quirk that goes into this very complicated area that seems simple on the surface. I'm going to turn now to duties and responsibilities. We don't usually see something like, apply stethoscope to patient's chest or anything like that. But what we see are really some more dedications of time and location. So let me talk a little bit about time. It's reasonable to have in an agreement, kind of an expected start and stop date, depending on the specialty. An expected start and stop time during the work week. So we might see physician is expected to be available and ready to see patients between 8 and 5, Monday through Friday, something like that. In surgical specialties, that doesn't make much sense, but in more of the clinic-based, that's a very reasonable thing to have. Call coverage. The questions with call coverage are usually how frequent it is, how heavy, in effect, is the beeper. Who are you sharing with? If I'm representing a newer physician going into a group, I might try to make sure that it's an equal ratio. So we don't often say like every 5th week he's going to have call, because what happens if they add a 6th or one of the physicians leaves if there were 5. But we might say that it's in an equal ratio or shares call coverage equally with all the other physicians, just to kind of flesh that out so the new guy isn't on all the time or on every holiday. So on and so forth. And, I kind of like to ask, is there a nurse practitioner who takes an initial call? And also another important issue, in this world of the mega systems that, employ, 150 primary care docs, are you responsible for taking call for patients in the entire network? Or is it just at your location? Some of that can be kind of risky. You're handling a call for a patient that you've never seen. That can get a little risky, at least according to some physicians and their risk factors. So knowing how the call is exactly done, while we wouldn't put that in agreement, I often encourage physicians to ask some questions about how that works. And then from the employer side, my thought is that it always seems best to have some sort of flexibility, but at least be transparent about it from the time of the employment contract so that it is fair. And if, as you've been there 10 years and you don't have to take call, there's nothing wrong with going ahead and putting that in the contract in most situations. I want to talk a little bit about location. And the location issue ties directly into non-competes. But what I like to have is usually in one of the opening paragraphs that physician agrees to be employed and to provide XYZ specialty services at XYZ location. And then I'll put it in parentheses and quotes and say practice location. And then I'll tie that practice location perhaps into the non-compete, which is usually based on a radius from one location. But I think it's important, if you live in a very spread out metropolitan area like Jacksonville, you don't want to take a job for the system at their beach location and then find that, you're going to be transferred without your consent out to the west side. That really impacts your work-life dynamic if you have to be in the car for an hour and a half a day. Never mind issues of call coverage. So we like to say that at least they won't change it without your written consent. Now, the employer might not want to do that. If I'm representing the employer, my employer probably wants some pretty good flexibility about where they assign physicians, perhaps not. But I think that often that they can agree to move is a good thing. So it's good to put a location in there, I think. You often see some administrative duties that you'll cooperate with, maybe supervision of staff. If you're supervising a bunch of nurse practitioners and PAs, we might want to address that a little bit differently than normal. And there's usually something that says that, you'll cooperate with billing. One hot issue lately has been that the physician will agree to close their EMR records within 48 hours of seeing the patient. Some of that's really necessary for accreditation standards, for billing standards, but that's been an issue of great contention too. Let me turn to educational responsibilities. this is important from both the group or employer standpoint and the employee standpoint. I'll often see a provision that will say, physician agrees that he will be board certified in rheumatology within 2 years of the execution of this agreement. Oh yeah, it'll take 2 years. That's good. That gives me plenty of time to pass the boards there. Know that sometimes your start date can get pushed back, or the 2 years can somehow just disappear really quickly, or the cycles of actually being able to take the test. Some of the board certifications are only held once a year or twice a year, and so if you fail the first time and then the second time that you could take it is past the 2 years, that can get dicey. And a lot of employers have in there that if you don't pass, then you are fired. So that's something to be very mindful about. I've had clients kind of look over that and in the past and miss some things. So that's an important one too. Let's turn now to the very boring subject of representations and warranties. In most physician employment agreements, there's probably a page or two of the physician representing and warranting a lot of things. These are very important, even though they seem like no-brainers. The Department of Health and Human Services prohibits groups that participate in Medicare from employing someone that has been kicked out of Medicare, so to speak. You want in your employment agreement something where the physician says, I've never been kicked out of Medicare. Now we say it in fancier legalese than that, but as an employer, you want to represent that they've told you all of these things so that you can be sure that if you are sued for not or cited for not checking these, that you could say, well, we asked him and this is what he signed as a representation. So those are all very important. Oftentimes also the representations and warranties are important because they are linked in via an internal reference to the termination provisions. So there might be in the for-cause termination section something that says we can fire you if you lose your license, if you are convicted of a heinous crime, and if you violate any of the representations and warranties in Section 15C. So you want to make sure that you look at those in 15C and make sure that they're right. From an employer standpoint, you definitely want that bridge or that link provision in there that's so that if they do violate one of those things and you find out they lied, that you can let them go right away. So while they might not be the sexiest parts of the agreement to negotiate or to analyze, we definitely look at them very closely because they can have some very strong effects. All right, let's move on to non-competes. These keep me very busy. So a non-compete is a clause that says after you leave, during the provision of the agreement, but typically the most important part is that after you leave, you agree that you will not work for a certain type of practice, doing a certain type of practice, in a certain geographic area for a certain length of time. So we kind of have two main factors, but perhaps four. So let's talk first about the geographic area. There is nothing in the Florida statutes that defines a geographic area. I will tell you that what I typically see here in my employment agreements that come across my desk are some sort of radius from some sort of location. So, you know, we used to have, well, we actually still have a big map of the city of Jacksonville up in our file room so that we can highlight and find the exact radius. It is a radius, so think third grade math. Do not think MapQuest. I had a client who came in once and said, so I MapQuested the distance and it's we mapped it, and if you map it, then it's one number, but if we do a radius, it's the other. So which number can I use? And I said, no, sorry, you have to use the radius. So keep that in mind. There are programs now that you can use, little apps that will do the radius for you, so those are handy. We no longer use our map in our file room, but that's an easy thing. That's an important thing. Usually where it comes up is, you know, a physician is coming in from out of town, let's say, and wants to join XYZ health system primary care, and their non-compete prohibits them from working within 10 miles of not just their practice location, like I talked about before, but of any practice location within the XYZ primary care network. So in Jacksonville, that could mean that you can't work between Amelia Island and Palatka and Jacksonville Beach and Callahan, let's say. I mean, it is, hundreds of square miles. And then the issue is the physician says, well, how could they enforce that? Is that really something a judge would enforce? Well, here's the skinny. The Florida statutes say that the employer has to demonstrate a legitimate business interest in prohibiting the activity. We haven't had, and this case is going to come up with the era of consolidation that's been going on for the past 3 years or so. It's going to come up, but it hasn't come up yet, where that specific question has been addressed by the courts in our DCA or definitely by the Supreme Court, about whether you could enforce a non-compete against a physician for XYZ health system who was working at Jack's Beach, who simply wants to go and leave and open an office in Fleming Island. Never, when he was in Jack's Beach, did he come close to getting patients coming all the way from Fleming Island to see him. Say this is a primary care practice where, for most primary care docs, people don't drive more than 5 or 10 miles. So that we don't have a really good answer on that yet. But there's one very pro-physician case that I'll talk about, and this one was fun to watch. It actually came up through our district here in Jacksonville. It was in Lake City. Florida hematology and oncology specialists sued to enforce a non-compete against Dr. Tumala. And Dr. Tumala actually left Florida Hematology and opened up an office basically right across the street in violation of the geographic prohibition in his contract, okay? So like I told you earlier, there's nothing in Florida statutes about a geographic area. There's nothing that says radius, counties. I digress, but sometimes for the geographic area, I'll see that the physician won't practice medicine within Duval, Clay, Putnam, St. John's, and Nassau counties. So sometimes they'll do it by counties. But what the Florida statutes do say is that the employer has to show that he has a legitimate business interest in that area. So let me digress another way for a minute and go back to my example with the big health system. The question that will become before the judge is whether they have a legitimate business interest in blocking that physician from working there. And they'll look at, well, is he going to steal patients away? Or, is it just that he's going to be competing against them? Is that enough under Florida law? Not necessarily clear at this point in time. But what Tumala did, opening up office right across the street, he said, I am not going to see any patient who was previously seen by my prior employer. And he stuck to it. And then when he went to court, he said, I didn't steal any patients away. They don't have a legitimate business interest in stopping me from seeing patients who are just now seeking out cancer treatment for the first time. They don't have a legitimate business interest in referrals from primary care physicians or from radiologists or from imaging centers, whatever, who refer me cases. I didn't pirate their patients, but I am competing against them for new patients. The judge in our district said that that was okay. It was appealed all the way to the Florida Supreme Court, and the Florida Supreme Court agreed with Dr. Tumala. So that case had the effect of sort of moving the scales a little bit more in favor of individual physicians as opposed to groups. I often get asked, are non-competes enforceable? And the answer is clearly yes. All around town right now, non-competes are being litigated and enforced. They are absolutely enforceable as long as they're reasonable, meaning they're enforcing a legitimate business interest. Let me talk for just a minute about the time period. Under Florida statutes, they presume that 2 years, if it's more than 2 years, it's presumed unreasonable. So when I'm drafting these for employers, I put them at least 2 years because that's, you're right at the period. We kind of toe the line in the sand there. But often, you know, for the fact of the matter is, if it's for 1 year, a physician usually can't, you know, sit on the beach and not work for a year. So the duration isn't necessarily that important. It's sort of cutting off the flow of patients. Also, if a physician leaves, the patients are either going to want to leave with him, or they're going to go to another physician in your practice. So usually you'd lose them right away. So if it's 1 year, 2 year, it doesn't really matter. In negotiating these, depending on the side, we might say that they don't apply in certain circumstances. For example, if I was representing a physician, I might ask, can you have the non-compete not apply if you terminate him without cause in the first 6 months, so he doesn't move down here and then get subject to a non-compete and have to sell the house he just bought? Something like that. And there are reciprocal arguments, but for the most part, from the employer standpoint, you want it to apply no matter what. All right, I'm going to touch just real quickly on profit sharing. This is kind of a world of the past with the influx of consolidation. Typically, we don't see promises in physician employment agreements that the physician will absolutely become a shareholder in 2 or 3 years. Usually it's say that they're eligible. And I'll often have physicians come in and say, hey, this is great, I'm going to be a shareholder in 2 years. And then I'll look at the contract and I'll say, what does eligible mean to you? It means you're eligible. That doesn't mean that you're definitely going to be a partner within 2 years. And then often when that does come into play, we talk about the buy-in, the cost, you know, the notes that you're going to have to sign on as a guarantor. Sometimes becoming a shareholder is a bit of a catch-22. That's definitely an issue that comes up a lot. Most of you on the call know the basics about general contract requirements, but I walk through these with physicians. I cannot tell you how often someone comes to me with a question about their employment contract and it is not signed. It is like a surgeon going into surgery with unclean hands. I don't mean to be too dramatic about it, but you know, I say, I don't know if this are you sure this is final? Or sure enough, they'll bring me the red line version of the last version that they negotiated. But so words to the wise is make sure that you have a signed contract, no matter which side that you're on. Some tips for negotiating from the physician standpoint. I actually have found that the groups that I represent kind of think highly of a physician that asks for some things. I think don't be afraid to ask. It shows that you have an idea of the business model, some business sense, that sort of thing. But most of the things on this slide are more tips for negotiating from the physician standpoint. Let me talk for just a minute about how we usually handle things. I always like to have a copy of the employment contract in a Word document so that we can redline it. Often we'll get PDFs. Most employers send them out in PDF as if they're not negotiable. Sometimes employers send them out in paper with sign here stickers on it so that you just sign, that sort of thing. But it is more precise and it saves everyone a lot of money if the lawyers can simply go in and make changes to the terms rather than write long letters that say in section 3.7, please change ABC to XYZ. It just takes a lot more time, and also some things can kind of be lost in translation in those kind of letters. And not to say that sometimes verbal negotiations between the parties are bad, they're good, but that's usually the best thing to do is get it in Word, and it definitely saves our clients money. And sometimes we negotiate on behalf of the client. Sometimes we just negotiate behind the scenes. I have some fantastic companies and group clients that might come to me to make some changes to their template, but I've developed the template for them, and their practice administrators can do a lot of it, the negotiations themselves, and only come back to me when they have questions. So a lot of times we're just behind the scenes. It's totally based on whatever our clients want to do. So with that, we have just a minute or 5 minutes, I guess, left in an hour. And yeah, so if anyone has any questions at this time, that would be great. Any questions? All right. Well, with that,
And I'm not kidding.
I think I'm going to sign off then. Thank you very much. Have a great day.
Step over here.